Madam President.
Senator from Missouri.
Madam President, I want to talk about the same topic that my good friend from Oklahoma has brought up. Actually, I was at the Supreme Court this morning listening to the arguments on this case, Sebelius versus Hobby Lobby, and another case involving a Pennsylvania company that I want to talk about as well. And of course, this case is, as the senator from Oklahoma has pointed out, starts with the Affordable Care Act and what many people, and I believe the Supreme Court will decide, is really a blatant violation in religious freedom in the way that act would be applied. There's nothing in the act that deals with the rule that sets those big fines up or establishes how those fines would be collected, or in fact, nothing in the act that specifies specific things that have to be in the so-called model plan. That all is up to the administration, all up to the Department of HHS, unless the court or the Congress do what needs to be done here, which is to say that there are certain boundaries that you can't cross. The Affordable Health Care Act, the so-called Affordable Health Care Act, which seems to be providing neither better health care nor better affordability, was signed into law 4 years ago this week. And in that 4 years, we've seen disastrous effects of the Health Care Act. One of those is the workplace effect, where more and more people work less and less. And why do they work less and less? Because for the first time ever, the government said that people had an obligation to provide insurance for somebody who worked more than 30 hours. Prior to that law, many people had insurance who worked less than 30 hours. It may not have been insurance that the President of the United States would have specified they had, but it was insurance that appeared to be working for them. But once the government says, here's what you have to do, the government ironically also appears to be saying, here's what you don't have to do. And so we know that the workplace effects are bad. We know that this is one of the principal reasons given for people working part-time without benefits instead of working either full-time or part-time with benefits. We see the cut in Medicare and the impact that has on seniors. We see the increasing level of amount of money that you have to spend before your insurance kicks in for so many people, and we know that this law is not working for American families or American individuals. Now we see a case where the law doesn't work for the Constitution. Specifically, the law forces businesses like Hobby Lobby that was mentioned by Senator Inhofe, the senator from Oklahoma, to offer health insurance for employees that covers services that violate their religious belief. Now, this is a company that's always prided themselves in their ability to offer health care coverage that was better than their employees might be able to get other places. This is a company that starts their non-seasonal employees at a rate at about twice the minimum wage, their lowest pay employee. This is not a company that's in any way trying to take advantage of their employees. This is a company that has given every indication through the existence of the company that they want to act in a certain way, a way that is comfortable with their faith. The penalties, if you don't do what the government says, the penalties are $36,500 per employee per year. $36,500 per employee per year. In the case of this company that has locations all over the country and has a significant number of employees, that's more than $450 million a year. If you just don't provide insurance at all, one of the points that was made by the government lawyers today, your option would be that you'd only pay a $2,000 penalty. A $2,000 penalty, $2,000 a year if you don't offer insurance at all, $36,500 a year per employee if you don't offer exactly the insurance that the all-knowing government has decided you need to answer. What a foolish position for the federal government to be in. Your penalty, if you're this big company, but privately held, closely held by a family, This happens to be a big and successful company, but not a publicly traded company. It happens to be a company that chose to incorporate, but incorporated within the ability of that family to do that, and this closely held way to do that. If you don't do what the government says, your penalty would be less than the insurance you're providing by quite a bit. If you don't provide insurance at all. If you don't do exactly what the government says, it's probably an amount of money that puts your company out of business. This company, Hobby Lobby, with more than 500 arts and crafts stores around the country, is a company that's being joined in the case today. The cases were joined together by Conestoga Wood Specialties, a company that manufactures kitchen cabinets. Their case was presented at the same time. This company was founded by the Hans family, a Mennonite family from Pennsylvania. A smaller company than Hobby Lobby, but a company still that holds their own religious beliefs and has a tradition of holding those religious beliefs in everything they do. Two companies of very different size. These are not companies that object to all of the things in the list of things the government says you have to offer. In fact, in the area of contraception, they object to only 4 of the things that happen after conception. The things that would create an abortion, in their view, after conception. They both, I think, traditionally offered other kinds of contraception, but this crosses their religious boundary. And so for these 4 things only, the government would say you'd have to pay $36,500 per employee a year. There are at least 46 cases filed concerning for-profit companies that have the same kinds of religious objections. More than 10 of those lawsuits in my state, the state of Missouri. And it's not just about one set of religious beliefs, it's about protecting all Americans' First Amendment rights to pursue their faith-based principles and what they believe. These happen to be a Mennonite family and an evangelical Christian family. There's, the largest Christian group in America. The Catholic Church has a broader sense of what they think would violate their religious beliefs. But the point here is not what the government is specifically trying to force you to do. It's that the government, under the laws that we have passed, should not be able to force you to do things that violate your faith principles. There are many faith-based groups that have different views on how you deliver health services. I've met with many of those groups over the course of the last 2 years since this rule came out. There are 84 different briefs that have been filed with the court on behalf of these 2 cases, suggesting as friends of the courts, here's something you should think about and look at. And on those 84 those amicus briefs, they're at least 3-to-1 in favor of the families that own these companies that want to be able to run their companies based on their faith-based principles. Not only are the numbers for people that are concerned about this large, but they include a very diverse set of coalitions of people who care. One brief bipartisan group of 107 members of Congress bipartisanly have filed a case that said you should uphold the law that the Congress passed that protects people's freedom of religion. Not to mention the Constitution itself, where freedom of religion is the first freedom mentioned in the first sentence in the First Amendment to the Constitution, and it is that important in our history of who we are. 21 states have joined this case on behalf of these companies. Doctors and women's organizations have filed briefs advocating that the court respect the religious rights of these companies. Protestant and Catholic theologians have filed briefs. The Rabbinical Council of America, the U.S. Conference of Catholic Bishops, the International Society of Krishna Consciousness, Crescent Foods, Halal Food Company, the Food Company, the Church of Jesus Christ of Latter-day Saints, the Coalition of Christian Colleges and Universities, a broad diversity of religious views, but they agree on one thing, which is that this is a principal tenet of who we are. Just as President Jefferson said in a letter he wrote to the New London Methodist in 1809, that of all the rights we hold, we should hold the right of conscience most dear. That once the government can start telling you what you believe and how to apply what you believe, we have given up the most fundamental of all freedoms. Congress has a long tradition of protecting religious liberty. The Congress enacted the Religious Freedom Restoration Act to ensure broad protection of religious liberty. The HHS regulations do not satisfy the high bar set by that act. That is a position that I hope the court upholds. The mandate is an enormous government overreach, and it violates Americans' constitutional rights. While this mandate severely fines religious individuals, it exempts plenty of other non-religious institutions. The administration's already exempted 100 million employees from the mandate for commercial or political reasons. People should also not be forced to give up their business to hold on to their faith, or to give up their faith to hold on to their business. These family businesses are not publicly traded corporations. There's not one court case. I'm not a lawyer, but I'm told this on the best authority. There's not one court case that diminishes the rights of these kinds of corporations. In fact, numerous federal courts have upheld the ability of for-profit corporations to bring racial discrimination cases. So you could have a racial profile as a corporation, but you couldn't have a religious profile as a corporation. This is an untenable position for the government to take. The Supreme Court here has heard this case today. I join my colleagues on both sides of the aisle and in both chambers to urge the court to preserve the fundamental religious freedoms that Americans have enjoyed, that the Constitution demands, that laws passed by the Congress and signed by the President overwhelmingly in 1993 continue to be the standard that is applied to our right of conscience, our right to believe what we want to believe and must believe and do believe. And I am pleased to be joined by my colleagues here, I think, to talk about this very same topic.